first case to come before the court this morning is the State of Ohio versus Alexis Sarvabui. Close, good, is that okay, the name?
Yes, Your Honor.
All right. Appellant will have 15 minutes to present your argument. If you wish to reserve time for rebuttal, you can reserve up to 5 minutes. Just let me know before you get started. Remain behind the podium because you're being recorded, so keep your voices up. We've read your briefs. We're ready to begin when you are.
Thank you, Your Honors. Good morning. Attorney Eric Hall on behalf of the appellant, Alexis Sarvabui. I'd like to reserve 5 minutes of my argument for rebuttal in this case, Your Honors. Thank you. Good morning. I'd like to talk just briefly about the facts in this case because I think they're important. The appellant was convicted of use, possession, sale of drugs, fourth-degree misdemeanor. This was the result of a traffic stop. She was trying to help out a friend, take the friend somewhere, find some location. She got lost. She didn't know where she was going. The friend apparently couldn't help her find the location. What happened was that there was a police officer in the area who initially tried to help them find their way. At some point in time, in some inquiry, he found out that the passenger, in addition to having some drug history apparently, also had an outstanding warrant. At that point, a K-9 was called, and located in the vehicle was a crack pipe. The appellant denied ownership of the crack pipe. The passenger stated to the officer, "I'll take the charge," essentially admitting to ownership of the crack pipe.
Well, is "I'll take the charge" actually an admission?
Well, it's certainly a statement against interest. I would at least go that far.
Okay, I'll give you that.
And that's part of the assignments of error that I have, Your Honor. I have 3 assignments of error. The first assignment of error is that the conviction was, the evidence was insufficient to support the conviction. In this case, the appellant denied ownership. The passenger's statements to the officer was that she would take the charge. I think that's more than reasonable doubt. Unfortunately, this case, and that's in my 3rd assignment of error, wasn't tried to a jury. Okay. Unfortunately, in this case, the passenger was not subpoenaed by defense counsel for the trial because they tried to question on direct and cross-examination on this issue of saying they're going to take a charge, and then explaining that to a jury that, look, folks, why would somebody say, there's outstanding warrants when they find drug paraphernalia in the car, and when there's a question, if nobody admits to owning it, there's a question of who, why would they say that they would take the charge? Certainly, that's an issue that would have been, reasonable doubt for the jurors, and I expect they would have came back with a not guilty verdict in this case.
Remind me, did they both deny ownership of the pipe originally? And then she said, well,
I don't believe that the passenger did. I believe that the appellant denied throughout. At the stop, during the stop, throughout the case, and she maintained her plea of not guilty. And at the trial, she maintained her innocence. She was ultimately convicted. Second assignment of error, convictions against manifest weight of the evidence for the same reasons. Here we have a case where the appellant says denies ownership, and you have somebody who's a passenger who had access, could have exercised control because it's found inside the car that she was riding in, could have exercised control or possession over this drug instance, this crack pipe.
Can't you say the same thing if that's the test and you're talking about constructive possession to a degree? Can't you say the same thing about the driver in terms of access?
Sure, in constructive possession, both of them could be found guilty. But in this case, though, Your Honor, the appellant said it wasn't mine, and you have somebody who's making a statement against interest. I mean, certainly this is a statement against interest that I will take the charge for whatever this instrument, whatever the charge is on this. I mean, at the time of the stop, she didn't know what the charge was, but she knew it was wrong. She knew that it was illegal, and she said, whatever the consequences are, I will take that. Okay. So under those circumstances, certainly a statement against interest, I think that certainly could lead a jury, a reasonable jury, to conclude that it belonged to her and not to the appellant. That brings me to my 3rd assignment of error. Okay. In this case, unfortunately, and I know ineffective assistance counsel is a hard standard to reach on appeal, but if you look at this, there's 4 different things I think that happened in this case that were were deficient, grossly deficient. One, not filing a jury demand in this case, okay? I think it's something that automatically, on any criminal case, you should file a jury demand. Not that you're gonna have a jury trial, not that you're gonna have a trial at all, but it certainly puts pressure on the defense in a lot of cases. You know, if it's a case that's an iffy case, they may not wanna try the case, they may offer some kind of a deal.
You mean it puts pressure on the state?
Yes, I'm sorry, that was
Okay.
my mistake, Your Honor, sorry about
That's
that.
all
It
right.
puts pressure on the state, okay? Also, you have more of an opportunity, in a lot of cases, you've got, in this particular case, you have 8 people who would have to make the decision. All you need to do is convince one that the state hasn't proven their case in a hung jury. You know, trying it to the judge, this is not the type of case that should have been tried to the court. It's not filing a motion to suppress in this case. It's a traffic stop. The appellant hadn't done anything wrong. She didn't have any outstanding warrants. The passenger did. So why is the appellant still there? What's going on? There's a canine coming and everything. There should have been a motion to suppress. The question is, was there probable cause to hold her there during this traffic stop? Okay. Of course, since no motion to suppress was filed, that was never fleshed out, and it can't be presented to the court, to the trial court, or to this court, what would have happened, or what ultimately would have been, you know, found, you know, in that type of a hearing, what the evidence would have showed. That was deficient on the part of the defense counsel. Third, look, in this case, the defense counsel asked for a continuance the day of the trial, which demonstrates to me that they were not prepared to go forward that day. The judge, the trial court judge, Judge McElvain, denied the continuance, and they ultimately had to go forward, even though they weren't prepared. Now, that's not a criticism of the trial court judge. That's a criticism of defense counsel. This case is not a complicated case. They should have been prepared to go forward that day, or if they needed a continuance to do some of the things what I just talked about, they could have filed that timely and gotten the time they needed in order to put those things together. They didn't do that. Finally, the
Let's stop there for a second. Did the defense counsel indicate to the trial court that they were not prepared to go forward? Specifically state that to the court?
No, that's my analysis of asking for a continuance at that time, that they're not prepared. If I ask for a continuance, it's generally a reason, but I do it timely, that's generally the reason why I do it, is at this time I'm not prepared to go to trial. So I ask for a continuance for more time. The most glaring deficiency in this case is the passenger. The passenger was never subpoenaed in for the trial on this thing, which is incredible to me, because to put that person on the stand, you have somebody who made a statement against interest, which I've talked about, and says, I'll take the charge for this. The jurors hearing that, you could explain to the jury that, listen, here's a person who had outstanding warrants, can be arrested anyway. They said, I'm going to take the charge. It certainly raises a reasonable doubt. Why would any of the jurors have stated they would take responsibility to take the charge for something that wasn't theirs? It's a real simple argument. And that argument never was made because the person wasn't subpoenaed. They should have been. So it's not just one it's not one omission or one deficient decision. It's several in this case. And ultimately, if you take all these things together, the trial court judge could only reach one conclusion in the case, and that's finding the appellant guilty, based upon the glaring lack of preparation and trial counsel's performance was grossly deficient in this case, Your Honors. And I would ask the court to consider the assignments of error that I just discussed. If you have any questions.
I have just a quick question. As far as location of the pipe within the car, was it inside the center console, or was it?
I believe it fell out, and here's what was interesting in the case, that there was a large, I believe it was some type of gym bag, some type of bag that belonged to the passenger. So, was it inside that bag? Did the passenger, did it fall out? Did it fall out of the passenger's pocket? It's important to note that the appellant denied ownership throughout. And here you have a person making this statement against interest that basically they would take the charge for this. Your Honors, I would ask you to consider that and reverse this conviction on those grounds, Your Honor, raising each assignment of error. Thank you.
May it please the court. court. My name is Brad Proudfoot, and I represent the respondent state of Ohio in this case. Instead of going back through what the 3 assignments of error are, I'd like to start with some of the factual issues that were raised in some of your prior questions. Appellant counsel was asked, did both of these individuals initially deny ownership of the item? And the answer to that is yes. They did in fact both deny ownership of it. And that can be found directly in the transcript itself on trial page 13, line 21. In fact, when the officer was questioned, and he was questioned as to, well, why would someone that doesn't claim ownership of it, why would they say, I'll just take it? And he said, well, I don't know. But she never once acknowledged that that was her crack pipe or meth pipe. I apologize. So there's that one glaring factual difference. As to the actual evidence in this case, the item was found directly next to the driver of the car, the appellant. Second, it was her car. She owned the vehicle. And then lastly, it was found in an open and obvious manner. So as to Judge Teodosio's question earlier, it was not in the center console. There was a small, I guess, a place where you can lie your keys or whatever right there. And that's where it was. In fact, there was testimony during the trial itself as to whether it could have fallen out of this large bag. And the trial court did not give any credibility to that argument. Earlier as well, constructive possession was brought up. And actually we believe that that's the basis for the trial court's decisions, the constructive possession. And that's knowingly exercising dominion or control over these drugs, even though they may not be in your immediate physical possession. Excuse me. Circumstantial evidence is sufficient in and of itself to support this. So here we have circumstances that show that it was the appellant's vehicle. The appellant was driving. The meth pipe was found directly next to her in plain view. So the trial court, in light of that, viewed that as her having possession, her knowing that that item was there. It's in plain view of her driving the vehicle itself. If I can move forward to a couple of other points in regard to the third assignment of error, the ineffective assistance of counsel. Appellant's counsel here said that a jury demand should be filed on all criminal cases. I think that's a bit of a stretch. I don't want attorneys that feel in their discretion it's better to try a case to the court to be worried about ineffective assistance of counsel if you're expected to file a jury demand every single time. I don't think that follows logic and reason. I think a lot of times that's the discretion of trial counsel, is whether to try a case to the jury, whether this is a case that's stronger suited for trial to the bench itself. Next, the failure to subpoena the passenger. Again, that to me is another issue of discretion. The trial counsel could have very easily have done research on her own that we were unaware of. She could have actually spoken with this individual. We don't know any of that because it's not on the record. And generally, there is leeway and discretion given to trial counsel in calling specific witnesses and putting their own defendant on the stand. Now, the failing to file a motion to suppress, initially, reading through appellant's arguments, I didn't see any analysis beyond speculation as to how this would have made a difference in the final result itself. There was nothing in there. There was no analysis as to the basis of what the motion to suppress would be. So if we don't even have that basis, how could that be used to show ineffective assistance of counsel if we don't know what the end game was? Now, as far as the continuance that was requested on the day of trial itself, if you look at the record, starting on page 4, there's discussion about this continuance, and in there, trial counsel states, my client has indicated she wants to request a continuance at this point so that we can do some sort of additional testing. And then, on the following page, it's noted that this case itself had been continued 3 to 4 times, but it's not indicated the reasons for those continuances. So
that was part of the question to the other, to opposing counsel. Was there any part of that discussion where defense counsel said, hey, Judge, I haven't had time to interview these witnesses, or I'm not really prepared to go forward? Anything that would indicate that they needed additional time to prepare for trial?
no, the only indication that was given was fingerprinting of the meth pipe itself. The defendant on that day had requested apparently to her trial counsel that she wanted to have it fingerprinted at this point. So that was the only indication that we have for the rationale behind requesting a motion for continuance. So. Then lastly, as it pertains to the evidence itself, I just want to reiterate that it's not so much ownership as possession as defined in the Ohio Revised Code. And I believe if we give deference to the court itself, the evidence that was in front of the court was the appellant defendant owned the vehicle, was operating the vehicle, and the drug paraphernalia was found immediately to her right in an open and obvious manner in the center console. I believe when you, in view of all of the foregoing, that the state of Ohio respectfully prays that the decision of the lower court was correct and that the appellant's conviction for possession of drug paraphernalia be affirmed. Thank you.
All right, thank you. You have your full 5 minutes.
Okay, thank you. Opposing counsel mentioned constructive possession, but in this case, constructive possession would have been overcome by the statement against interest made by the passenger. I believe that overcomes constructive possession. Somebody saying they'll take the charge. A jury could have reached the conclusion that basically somebody wanted to take the charge as admission that it was belonged, that they possessed the crack pipe. So that would have overcome constructive possession in a trial. With regard to filing a jury demand, the reason that you should file a jury demand is so that the defendant and their attorney can make the decision what type of trial, if any trial they're going to have, rather than, rather than have it made arbitrarily by a court simply because you didn't file the right paperwork in the right.
How do we know that the defense counsel didn't go through that analysis and think, hey, this is more of a legal question for the court, I want to try it to the bench?
We don't know that from the record, Your Honor. There's no way to tell that. And also, with regard to opposing counsel's arguments about the 3 to 4 other continuances, we don't know why they asked. But I would say that that's unusual in this type of case, a misdemeanor case, 4-3 misdemeanor, to request a total of 4 continuances. Okay. I would suggest that every one of these continuances could not have been based upon the defendant's request or desire to do something. Some of them had to have been on the part of the defense counsel's, whether readiness or some other decision, but it could have been maybe a conflict with rules of superintendents or something like that, conflict. But not all of them would have been attributed to the defendant. As far as the motion to suppress, without having filed one, we don't know what the outcome would have been. But what I do know, or what we do know, is that would have given defense counsel a chance, an opportunity to try to suppress the evidence at the beginning of this case, that it would never got to the point of the trial. And that didn't happen. The traffic stop, so it's certainly, and if you look at the record on this, you look at the transcript, this is the type of case that certainly a motion to suppress would have been viable. Whether it would have succeeded or not, we don't know. There's no way of knowing.
But counsel, for purposes of ineffective assistance of counsel and the motion to suppress, isn't whether it would have succeeded or not, or likelihood of succeeding, kind of our standard of review? Maybe not kind of, is our standard of review?
Tough standard.
Tough standard,
Yeah.
yeah.
Before this court today, I can't tell this court that I'm absolutely 100% certain it would have succeeded. I
No
don't know.
one can.
Yeah, exactly. But I think
it's
it's,
test though is a reasonable probability of success. It's not,
well,
Show off.
Just kidding. It's exactly what Judge
Thank you.
Callahan said, reasonable probability.
thank you, Your Honor. I think if you look at this, okay, you look at the first two assignments of error, the sufficiency of manifest weight, the statement against interest certainly raises the issue of reasonable doubt. I think if you look at the third assignment of error, the ineffective assistance of counsel, it's not just one thing, it's several things. It's several things. The case was just not handled properly, and defense counsel's performance fell below the standard for licensed attorneys in this state and this type of case, Your Honor.
Attorney Proudfoot said that you didn't, when you were talking about your motion to suppress, you didn't give a basis as to why suppression could have been granted. There was no argument as to what the basis for suppression would have been. It was open and obvious according to Attorney Proudfoot. And so what would be the argument as to?
I think at that time, I'm sorry, I didn't interrupt. I think at that time, the fact that the pipe was discovered, whether this stop needed even to be prolonged, the appellant hadn't committed any crime. Up until the point of discovering the pipe, there was no allegation that she had committed any crime. The passenger, on the other hand, had an outstanding warrant. So the appellant was actually, should have been free to leave throughout the stop. There's no reasonable articulable suspicion or probable cause to hold her there because the passenger had some type of a problem or issue. There was no reason to do that, and that would have been the basis of the motion to suppress. Probable cause, reasonable articulable suspicion. This was all based upon the passenger. Okay, everything up until the point that they found the pipe, and then at that point, for lack of better words, things went south at that point. So I would ask the court again to, in reviewing this, to reverse the appellant's conviction in this case. Thank you.
Thank you very much. Thank you both for very good arguments here. We will take this matter under advisement, issue our written decision in due course. It will be mailed to both sides as well as posted on our website and on that of the Supreme